Hello everyone. I'm Ted. And today we will discuss Chapter 19. Industrial Disputes and Settlement. Let's start. Industrial disputes, preventive machinery. Industrial disputes, preventive machinery. The methods for prevention of industrial disputes are explained below. 1. Trade unions. Strong trade unions help prevent industrial disputes. They can bargain with employers effectively and seek quick redressal of grievances. Industrial relations will be sound only when the bargaining power of the employees' union is equal to that of management. A strong union can protect the employees' interest relating to wages, benefits, job security, etc. 2. Joint consultations. To prevent industrial disputes, 2 ways of joint consultations are adopted. Work committees and joint management councils. 1. Works committees. As per the provisions of the Industrial Disputes Act, 1947, works committees have to be set up in all those industrial units which employ 100 or more persons and are composed of an equal number of employers and employees' representatives. The committees are given the responsibility of removing the causes of friction between labor and management in the day-to-day functioning of a unit. A works committee is a purely consultative body and not a negotiating body. The committee offers greater participation to worker in day-to-day affairs, ensures close mutual interaction between labor and management, generates a cooperative atmosphere for negotiations between the two parties, opens the door for unions to have a clear view of what is going on within a unit, strengthens the spirit of voluntary settlement of disputes. A number of issues come under the purview of works committees like wages, benefits, bonus, hours of work, terms and conditions of employment, welfare measures, training, transfers, etc. Works committees in India did not succeed on account of several reasons. The scope and functions of these committees were not clearly defined. The advisory nature of the committee did not help matters either. The committee, in the absence of legal powers, could not enforce its own decisions. Multiple unions had their representatives in the same committee at the plant level. This had only escalated tensions among members. Often, employers used these committees, filled with their own yes men, to fight workers' associations. To complicate matters further, unions did not welcome the formation of these committees, fearing dilution of their power. Unions looked upon these as their rivals. Many works committees do not function at all, for they exist only on paper. They do not meet at regular intervals and do not discuss matters of real importance. 2 Joint Management Councils, JMCs. In the Industrial Policy Resolution, 1956, the need for joint management councils consisting of representatives of management, technicians, and workers was emphasized. Management must supply facts regarding the working of a unit, and the council discusses various matters across the table and recommends steps for improving efficiency. The main features of the scheme are given below. The scheme is voluntary, not obligatory. The JMC should consist of equal numbers of representatives of workers and employers, minimum 6 and maximum 12. JMCs should look after 3 areas: information sharing, consultative and administrative. Matters relating to welfare, safety, training, holiday schedules, formulation of standing orders, etc., all come under the above 3 categories. Decisions of the JMC should be unanimous and should be implemented without any delay. The JMCs should not encroach on the jurisdiction of works committees. The JMC members should be given proper training. Representation of workers to the JMCs should be based on nominations by the recognized union. Initially, JMCs should be constituted in a large number of public and private sector units being over 500 or more workers, where there is a strong trade union, and where the labor management relations are sound. Originally, the idea was to be implemented in over 150 units, but at present about 80 are operating in public sector units such as Hindustan Insecticides, HMT, Indian Airlines, Air India, etc., and in a large number of private sector units such as Tisco, Arvind Mills, Modi Spinners and Weaving Mills, Travankari Rubber Works, etc. The experiment has not succeeded in India, as one expert commented. The works committees and the joint councils have failed. It is living in a fool's paradise to believe that labor will be an active partner in management. Factors such as lack of interest on the part of workers, union rivalries, unfavorable management attitudes, etc., are mainly responsible for the unsatisfactory performance of JMCs in India. 3. Standing orders. The term standing orders refers to the rules and regulations which govern the conditions of employment of workers. They specify the duties and responsibilities of both employers and employees. Through standing orders, the conditions of employment are sought to be regularized, paving the way for industrial peace and harmony. The Industrial Employment, Standing Orders, Act of 1946 provides for the framing of standing orders in all industrial undertakings employing 100 or more workers. As per the provisions of the Act, employers have to formulate standing orders in consultation with workers and submit to a certifying officer. The matters to be highlighted therein are: A. Classification of employees. B. Hours of work, holidays, paydays, wage rates. C. Shift working. D. Attendance and late coming. E. Leave rules. F. Temporary stoppages of work. G. Termination, suspension, and disciplinary actions, etc. The Act has been amended a number of times, the latest in 1982. The 1982 Act provides for the payment of a subsistence allowance to workers who are placed under suspension. 4. Grievance procedure. A grievance may be defined as any real or imagined feeling or personal injustice which an employee has concerning his employment relationship. Grievances have to be redressed promptly. Any attempt to suppress them may backfire and may find expression in violent forms later on. A model grievance procedure, as suggested by the Indian Labour Conference, 1958, has more or less been widely accepted now in India. Under this model, both the employer and the workers are expected to follow certain steps so as to put out the frictions between them. Another method commonly used to prevent industrial disputes, workers' participation in management, has already been explained previously. 5. Code of discipline. Over the years, several legislative measures have been adopted in India to promote discipline and harmony between employees and employers. Sad to relate, the results have not been very encouraging. As a remedy, the second five-year plan has suggested that both employees and employers must formulate and abide by a voluntary code of discipline. In pursuance of this suggestion, the 15th Indian Labour Conference suggested a code of discipline in 1957. The Central National Labour Organizations, INTUC, ATUC, HMS, UTUC, and Employers Associations, EFI, AIOIE, AIMO, have agreed to enforce the code with effect from June 1, 1958. The code aims at preventing disputes by providing for voluntary and mutual settlement of disputes through negotiations without the interference of an outside agency. Moving next. Industrial disputes, settlement machinery. The Industrial Disputes Act, 1947, provides a legalistic way of settling disputes, where the employer and the unions fail to reach an agreement bilaterally. The provisions of this judicial machinery may be listed thus. 1. Conciliation. Conciliation is a process by which representatives of workers and employers are brought together before a third person or a group of persons with a view to persuade them to come to a mutually satisfying agreement. The objective of this method is to settle disputes quickly and prevent prolonged work stoppages if they have already occurred. The conciliation machinery in India consists of the following. A. Conciliation officer. According to the Industrial Disputes Act, 1947, the central and state governments can appoint a conciliation officer to mediate in all disputes brought to his notice. The officer enjoys the powers of a civil court. He can call and witness disputing parties on oath and interpret the facts of the case. He is expected to give judgment within 14 days of the commencement of the conciliation proceedings. His judgment is binding on all the parties to the dispute. The conciliation officer has a lot of discretion over the ways and means to be followed to bring about a settlement between the disputants. He may do all such things as he thinks fit for the purpose of inducing the parties to come to a fair and amicable settlement of disputes. B. Board of Conciliation. when the conciliation officer fails to resolve the disputes between the parties, the government can appoint a board of conciliation. The board of conciliation is not a permanent institution like the conciliation officer. It is an ad hoc, tripartite body having the powers of a civil court, created for a specific dispute. It consists of a chairman and 2 or 4 other members nominated in equal numbers by the parties to the dispute. The chairman, who is appointed by the government, should not be connected with a dispute or with any industry directly affected by such dispute. The board, it should be remembered, cannot admit a dispute voluntarily. It can act only when the dispute is referred to it by the government. The board conducts conciliation proceedings in the same way as conducted by a conciliation officer. The board, however, is expected to submit its report within 2 months of the date on which the dispute was referred to it. The boards of conciliation are rarely constituted by the government these days. In actual practice, settling disputes through a conciliation officer was found to be more flexible when compared to the board of conciliation. See Court of Inquiry. In case the conciliation proceedings fail to resolve a dispute, a court of inquiry is constituted by the government to investigate the dispute and submit the report within 6 months. It is merely a fact-finding body, and its findings are not binding on the parties to the dispute. The conciliation machinery has not proved its worth in the country so far. The reason is quite simple: very few cases are referred for conciliation. The few cases that are referred to it remain untenable as they fail to meet the legal stipulations. In some cases, disputes are filed, only to be withdrawn later on. A large number of cases remain pending, as the disputing parties do not supply relevant information initially. The heavy work pressures of the officers also come in the way of clearing cases within the 14 days time period. Conciliation, as pointed out by the National Commission on Labor, is only treated as a first hurdle by the parties, who prefer to go to the next stage without showing any interest to settle the case quickly. As things stand now, both labor and management do not seem to repose their faith in the efficacy of the machinery created by the government. 2. Voluntary arbitration. When conciliation proceedings fail to settle the dispute, the conciliation officer may persuade the conflicting parties to voluntarily refer the dispute to a third party known as arbitrator, appointed by the parties themselves. The arbitrator listens to the viewpoints of both parties and delivers an award or judgment on the dispute. He, however, does not enjoy judicial powers. The arbitrator submits his judgment on the dispute to the government. Thereafter, the government publishes the award within 30 days of its submission. The award becomes enforceable after 30 days of its publication. The arbitration award is binding on all the parties to the agreement and all other parties summoned to appear in the proceedings as parties to dispute. Before delivering the judgment, the arbitrator is expected to follow due procedure of giving notice to parties, giving a fair hearing, relying upon all available evidences and records, and following the principles of natural justice. Despite the best efforts of government to give a place of prominence to arbitration, it has not been a resounding success in India. The main hurdles that came in the way were: dearth of suitable arbitrators enjoying the confidence of disputing parties, the complicated procedure to be followed in voluntary arbitration, the payment of arbitration fees. Unions can seldom afford to pay such fees equally with management. The absence of recognized unions which could bind the workers to a common agreement. Easy availability of adjudication in case of failure of conciliation or negotiation. Absence of a legal remedy for appeal against the award given by the arbitrator. With a view to promote voluntary arbitration, the government has appointed a tripartite National Arbitration Promotion Board in July 1967, consisting of representatives of employers, trade unions, and the government. The board keeps a panel of experts who could act as arbitrator. The board evaluates the progress of voluntary arbitration from time to time and advances suggestions for its improvement. It also tries to evolve principles, norms, and procedures for the guidance of the arbitrator and the parties. 3. Adjudication. Adjudication or compulsory arbitration is the ultimate remedy for the settlement of disputes in India. Adjudication consists of settling disputes through the intervention of a third party appointed by the government. An industrial dispute can be referred to adjudication by the mutual consent of the disputing parties. The government can also refer a dispute to adjudication without the consent of the parties. The Industrial Disputes Act, 1947, provides a three-tier adjudication machinery, namely labor courts, industrial tribunals and national tribunals, for the settlement of industrial disputes. Under the provisions of the Act, labor courts and industrial tribunals can be constituted by both central and state governments, but the national tribunals can be constituted by the central government only. 1. Labor Court. The labor court consists of one independent person, called as presiding officer, who is or has been a judge of a high court, or has been a district judge or additional district judge for not less than 3 years, or has held any judicial office in India for not less than 7 years. The labor court deals with disputes relating to a. The propriety or legality of an order passed by employer under the standing orders. b. The application and interpretation of standing orders. c. Discharge or dismissal of workers, including reinstatement of, or grant of relief to wrongly dismissed persons. d. Withdrawal of any statutory concession or privilege. e. Illegality or otherwise of a strike or lockout. f. All matters except those reserved for industrial tribunals. 2. Industrial Tribunal. This is also a one-man ad hoc body, presiding officer, appointed by the government. It has a wider jurisdiction than the labor court. The government concerned may appoint 2 assessors to advise the presiding officer in the proceedings. An industrial tribunal can adjudicate on the following matters. a. Wages including the period and mode of payment. b. Compensatory and other allowances. c. Hours of work and rest periods. d. Leave with wages and holidays. e. Bonus, profit sharing, provident fund and gratuity. f. Shift working, otherwise than in accordance with the standing orders. g. Classification by grades. h. Rules of discipline. Rationalization. j. Retrenchment and closure of establishments. k. Any other matter that may be prescribed. 3. National Tribunal. This is the third one-man adjudicatory body to be appointed by the central government to deal with disputes of national importance or issues which are likely to affect the industrial establishments in more than one state. Moving next. Appraisal. Appraisal. Adjudication has proved to be the most popular way of settling disputes in India. More than 90% of the disputes are settled through this judicial process every year. However, the actual functioning of machinery is far from satisfactory because of 1. The delays involved. 2. The inefficient implementation of the awards. Adjudication has been criticized thus. a. On the procedural plane, adjudication is dilatory, expensive, and discriminatory as the power of reference vests with the appropriate government. b. On fundamentals, the system of adjudication has failed to bring about industrial peace, has prevented voluntary settlement of industrial disputes and growth of collective bargaining, and has come in the way of healthy growth of trade unions. Quite a good number of disputes are reported to be pending with labor courts and industrial tribunals for over 4 or 5 years. The complicated procedures, red tapeism, bureaucratic delays, high loss of adjudication which only an employer can bear, have all come in the way of prompt settlement of disputes through the adjudication machinery. That's all for this video. Thank you for watching. This video is brought to you by Bookstune. Like this video to encourage us. Share this video to spread the knowledge. And subscribe to this channel for latest update.